Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
This is Serious Privacy by TrustArc. Here are your hosts, Paul Breitbart and Kay Royal.
In May 2014, the Court of Justice of the European Union ruled in a case brought by Mario Costeja González, a Spanish gentleman that really wanted his name to disappear from the internet forever. He won the case, although he will now forever be remembered because of it. The Costeja case, also known as Google Spain, introduced the right to be forgotten, the delisting of search results from search engines in case they are no longer relevant. A good thing for data protection, you would say. Our guest today has some concerns, however. Chris Docksey, the Honorary Director General of the European Data Protection Supervisor, has previously written about this for the German Verfassungsblock, writing about the fair balance between privacy on the one hand and press freedom in the online context on the other, and the possible chilling effect of self-censorship for local journalism. You'll hear much more about these concerns today. And as last week, Kay is on vacation, so I'm welcoming back Ralph as my co-host. My name is Paul Breitbart.
My name is Ralph O'Brien, and welcome to Serious Privacy. So welcome, Chris. Welcome, Chris. Welcome, Chris. It's a pleasure to be on the podcast with you today.
Good to be with you, Ralph, and Paul, of course.
Yeah, wonderful. So it's my duty to kick off with the unexpected question as taking over, of course, our good friend Kay, who, as I understand it, is still sailing around the ocean on some sort of, yacht or fully expensive, all expenses paid luxury tour. But the unexpected question today is, what are you most grateful for? What are you most grateful for? So, Chris, I think we'll come to you first. What are you most grateful for at the moment, Chris?
Oh, at the moment, gosh, that narrows it down a bit. And are you talking about professionally or personally?
Oh, I think your choice. So mine's going to be personal, but your choice, of course.
Well, I think it's a little bit boring, but the thing that really helps me sleep at night is having a wonderful wife and 3 fantastic daughters. I just, and the only thing that I'm sorry about is we've lost our 2 cats, who were also female. So I was completely outnumbered, but they've passed away now at the ripe old age of 20 years.
Oh, wow.
But they do say you don't, when you're dying, you don't worry about not having done the extra half hour in the office. And, having grown up adult women as immediate family is rather nice. That's what I'm grateful for.
Do you know what? I agree. I've worked in both the security and privacy professions. And one of the things I really love about the privacy profession is the balance of male and female. Whereas in the security profession, it was mostly male, and that sometimes led to some quite toxic outcomes. So I actually do like the balance that are more that we actually find in the privacy community. Question, Paul, what are you most grateful for?
With you stressing the balance, I think we owe our listeners an apology, because for the first time in 3 seasons of Serious Privacy, we now have an all-male panel, which isn't something that we usually do, if only by the nature of our co-host. But yeah, this is sheer coincidence. We scheduled with Chris a long time ago to have this conversation today. And it is what it is, but no worries. We'll make it fun nevertheless. What I'm grateful for, it's in the same range of thoughts. It's a great group of friends that surround me. And even if I'm working really hard, that check in, do sanity checks, and just are there to go for drinks and good food and catch up and gossip and share all the sadness that may also occur in life. So, I'm really grateful for that.
Yeah. And not to make the podcast on too much of a somber note, but my father has been in poor health recently, bless his heart. He's made a speedy recovery. So I'm going to talk about my family as well. I don't really talk about personal things on the podcast, but my mother and father separately gave me naturally a really pleasant upbringing, better than a lot of people have in the world, and really opened my eyes to a liberal and open and inquisitive view of the world. They're both bringing very different things. So I'm going to be thankful for them, and perhaps use this as an opportunity to publicly say thank you to my parents for where I am now. So there we go. How's that?
Very good.
But we're not here to talk about us. We're here to talk about you, Chris. We're not here to talk about us. We're here to talk about you, Chris. So I'm here to talk about the journalism and the balance between the right to be forgotten and the right to freedom of speech, the freedom of the press compared to the rights of the individual for privacy. And that's going to be a hell of a long conversation. But before we get into that, in case our readers or our listeners don't know anything about you, Chris, perhaps we could just start with a little bit of an intro to you and who you are.
Oh, gosh. Well, that's of less interest. I used to be the director of the EDPS, and before that, I was a commission official in the legal department pleading cases before the Court of Justice. Most relevant, I think I've been doing data protection now for about, 22 years. It was about the year 2000 I started. And the great thing about data protection, or the unfortunate thing, depending how you look at it, is it never ceases. Just bring up new challenges, trying to understand this, that, or the other. So that's me in a nutshell.
98 was when I started, and, I've often described it as fighting the rear guard of a losing action for the last 25 years. But I hope there's hope ahead of us.
Well, I think there is. I think we're reaching a tipping point. Remember, after the GDPR came into force, after about a year, everybody was pretty disappointed. They were saying, well, what's happening? And there was all these anguished articles about if this legislation isn't applied, then, it will just become a dead letter. But now, we are seeing two things, certainly here in the EU. One is an explosion of the case law before the Court of Justice. And that means it's an explosion of case law at national level, because these cases are all references from national courts. And the other thing is the data protection authorities have really got going now in imposing fines. Mm-hmm. And I'm there, actually, don't know your views, Ralph, because the privacy podcast I listened to was with it's basically Paul and accountability. I'm convinced that the really important concept is accountability in our area. And that, being a data protection authority is not about fining, as Paul thought it was in his youth.
Yes.
It's about helping people compliant. And that's how I forgot to mention, I'm a member of the Data Protection Authority of Guernsey. That's how our authority works. We really prioritize helping people to understand what they should be doing. And that's accountability. But nonetheless, I do think that it helps data protection officers and privacy officers to be able to say to the C-suite, well, if we do this, we're going to get fined just as they got fined in ... Mm-hmm. So it's these two developments, for me, are showing that the GDPR is really being taken seriously now in a way that we were a bit worried back in 2019 that it wasn't.
Well, and even a bit longer ago, when you and I were still attending meetings of the Article 29 Working Party, I recall that at points people were complaining, why don't we have any case law to discuss? We only have the enforcement by the data protection authorities. This was predating GDPR, so there were no fines, only enforcement orders or compliance orders. And we had no case law. And then we got suddenly the first few big cases, with Costeja being one of them, with the Schrems 1 decision. And then we were complaining, why do we have all this case law? Because we cannot keep up.
Yeah, so, I remember very similar. It was back in 2016, 2017, when, we had the GDPR passed, when it wasn't yet enforced from, the May 2018. And, I saw job adverts asking for people with 10 years of GDPR experience, which I thought was hilarious back at the time, right? So, we could never have these things too quickly. And answering your question, Chris, I've got more of a balanced view. Yes, I think like Paul was in his younger days, like I was in my younger days. Oh, where's the enforcement? Where's the enforcement? But I do believe we need carrot and stick. And actually, I think I said in the last podcast that it was Peter Hustenings who actually said to me, actually, if we're doing our job properly, we shouldn't need enforcement because people should be following the law. It's the regulator's job to try and encourage people to follow the law. And if that can be done with a letter or a rebuke or just a conversation, perhaps, or some education, we shouldn't need to carry an enforcement action. Enforcement should be left for the consistent, repeat, serious, if you like, offender. Everyone else, an encouraging word or a quick conversation, may well be the route. But if carrot and stick, you do get people who won't move without enforcement, who won't move without the gun to their head. And, it's blackmail, isn't it? Do this or else bad things will happen. I've always preferred to be do this and good things will happen. Do this, you'll get your data governance right. Do this, you get your PIAs and you'll add functionality and add value to your product.
Do this and you make more money.
Yeah, exactly. Make more money. That's what businesses respond to at the end of the day, isn't it? That's what businesses respond to. So let's go back to the Consuela case. So the big difference between these cases you wrote about, Chris, and I know, as I understand it, the Consuela case, is in the Consuela case, it was versus Google, right? Mr. Consuela, even though the publication of his bankruptcy, I believe it was in the La Vanguardia, which was a local Spanish newspaper, he actually took out his court case against Google being the person that people used as a search engine to find it on La Vanguardia. Now, these cases are different, Chris, and I'm wondering if you could explain the difference in this case with, Herbane versus Belgium, Biancardi versus Italy, why they're different from the Consuela case.
Well, just to go back to the case of Mr. Manuel Conseja, he took the cheaper route, and he complained to the Spanish Data Protection Authority, and he wanted them, as you say, Ralph, to go against both the newspaper and Google, but the AEPD, the Spanish Data Protection Authority, only made an order against Google, and I assume very strongly that was because that they didn't think it was appropriate to go against the newspaper. Mm-hmm. So what we ended up with is judge-made law as a result of the Google case, something different to the right of erasure, because the right of erasure means you get it deleted, gone. Mm-hmm. And it's not very helpful that in GDPR they talk about the right of erasure brackets, right to be forgotten. But this is judge-made law, and what it says is that you can ask the search engine, usually Google, but not only, to and there's all these words: dereference, delist, de-index, the as in his case, the article about the forced sale of his social security purposes to pay social security bills of his property. So he wanted that gone. And, there are problems about the system, but I actually think it works very well. Mm-hmm. You go to the search engine. If you disagree with what they say, you can go to the Data Protection Authority. Mm-hmm. If somebody else disagrees with what they say, they can go. There is control over it.
What some people actually forget is that was under the previous legislation, actually. It wasn't really under the GDPR. There wasn't a right to erasure or a right to be forgotten. It was actually under the sort of retention elements of the Data Protection Directive at the time, wasn't it?
Yeah, and the GDPR is
the right to object for a legitimate interest.
It's codified the words. But I reckon it works, and it's a little bit like the polluter pays principle. That the search engines are responsible for doing this and putting the resources in, because this can be very resource intensive to responding to requests to de-index or dereference, whatever you want to call it. So, working well. The Advocate General in that Google Spain case, by the way, said this is a bad idea. We don't want to have the press reports endangered. We don't want to rewrite history. And the way it's worked up to now, and certainly in the EU context, this EU law context is still working, is you go against the search engine and you leave the newspaper untouched. There was a WP29 report, and it said, where you've got narrowband search engines, like a newspaper's online search engine, you shouldn't really go against those. You should go against the wideband general search engine. Then you have these two cases called Biancardi and Urbain before the national courts, and very odd, none of them talked about the right to freedom of expression as embodied in the GDPR in Article 85 and the need to find a balance. They didn't do that. And the reason I'm worried about them is I see them as allowing privacy and data protection to be used, in my view, abused, to limit free speech, to limit journalism. And one of these cases has a particular impact on small local newspapers. And the problem, as we know, is that small local journalism is dying. And there's all this research showing that it's small local journalism that really keeps local politicians on their toes and even has an effect on national politics. I seriously read an article saying that, one of the reasons for things like disillusion with politicians centrally is that there was a dearth of local press reporting and holding local politicians to account. And this thing, well, politicians, who cares, spills over into the national context.
I think that's really fascinating, because we've got two fundamental human rights at play here. We've got, your Article 8 right of privacy versus your Article 10 of expression. And there's the article in the middle that kind of says, hey, how do we balance these two? Really, I want to speak from a UK perspective. We very recently had something called the Levson inquiry over here, sometimes known as the phone hacking inquiry, whereby we had a lot of the tabloid press here in the UK going into people's voicemails on their mobile phone, celebrities, royalty, people who had lost their children. And we had this whole inquiry over here about, where should the limitations on the press be? Where is the balance between the needs, the public interest to expose people's wrongdoing, let's say, and the needs of the individual, the needs of the many versus the needs of the one, Star Trek fans, the needs of the many. And that, this is what we're talking about here, aren't we? The needs of the many versus the needs of the one. We're talking about the balance between public interest and individual interests, the balance between freedom of expression. We also saw in the UK the Cliff Richard case, which was Cliff Richard, for those people that don't remember him. It was a fairly aged pop star, singer, actor who was indicted in almost the child abuse from the 70s, Operation Newtree we had in here in the UK. But when the police went to try and find evidence, there were helicopters swarming his house, right? It had been leaked to the press. It had been leaked to the media. And therefore, you had the press all, surrounding his house. And of course, when he was found to be innocent and no evidence was found, that's a retraction on page 43 of a newspaper, several weeks later. And the damage is done to the reputation. And he quite rightly took out a data protection, case for damages. So, it is a really interesting societal question. But in this case, Chris, you believe the balance is wrong?
Yes, I mean, you talk about the phone hacking and the Cliff Richard case, and those are cases of abuse. And I don't think the press should be immune from basic legal standards. But in fact, the Court of Human Rights has led the way in terms of laying down criteria for the rights of even public figures like Cliff Richard. You still retain a zone of privacy, but it's a reduced zone. But the situation I'm talking about is not a situation of abuse. In both cases, it's a situation of information that was actually factually true in both cases. And it was just a question of whether applying the right to be forgotten, it was the right thing to do to de-index that. And then who should de-index it? In one case, the Italian case of the journalist Mr. Biancardi, he had a local website and he published an article based on police reports about a fight between two 70-year-old restaurant owners in their restaurant. And they were brothers and one stabbed the other. And so he wrote an article in he had a little local news website about it based on the police report. In the other case, and all the relevant facts, this is an important thing about the case, they all happened over the next 2 or 3 years after that report. In contrast, the Urbain case was about a major Belgian newspaper, Le Soir, which reported in paper on an accident by a doctor who dangerous driving in the 90s, and it ended up killing and injuring people in the other car. He went to jail. He came out in about 2006. And once Le Soir put its archives online, suddenly this doctor, a few years ago, finds his name is popping up with this, where he's paid his price to society. But in both cases, the actual information was true. It was just, was it Was it in the public interest for it still to be available? Now, if you'd applied the right to be forgotten in the way that we're used to it, then Google in both cases, and Google was involved in both cases, would have simply de-indexed the information.
As it should be following the Costeja case.
Yeah, but for reasons I don't know, well, I can imagine what they are, and some are favorable and some are unfavorable to Google. In both cases, Google did not do the de-indexing. It didn't do it in the Le Soir case because it wasn't the individual concerned who asked them; it was the newspaper, and Google just said, "You're not the individual concerned, and we're going to do anything." And I don't know why they didn't do it in the Italian small website case. And what the courts did, so we're talking about national courts going up to the Supreme Court in both Belgium and Italy. So this is just a question of two decisions by the Court of Human Rights, much broader. They said it's okay to say to the newspaper, you do the de-indexing, the dereferencing, and so on. You do it. And they took the view that this is okay because the newspaper still has its archives, still has its originals there, and all you're doing is having it do the same as Google. But there are some problems with that. At the hearing of the Urbain case, by the way, as it was appealed, and the Grand Chamber of the Court of Human Rights agreed to hear it, the newspaper said, I think, well, we don't have multiple databases. We have our archives online. So if we dereference it, it's not there anymore. So you're actually taking away the right of freedom of information of you and me and the public to access the archives of a newspaper. In the Italian case, it was slightly different. Firstly, the period involved was very short. It was just 2.5 years from the publication to the restaurant owner saying, I'd like you to delist it, please. And as soon as he was refused, he went to court. And he went to court. Google was a co-defendant, but Google was dropped during the proceedings. And finally, it was only the little local news media site that was sentenced to pay a fine. And it itself, to try and get out of this problem, had dereferenced it itself. As well as and by the way, as a result of this, everybody else piled in, and there were about 240 requests to take down for this little website.
Wow.
And 40 cases. They started by just, in desperation, just doing it. And it became too much, and it became insolvent. It was sold. There's no more local archives in little town of Pescara as a result. You can see on the YouTube, you can see the citizens led by the mayor going to Rome and protesting against the decision of the Supreme Court and so on, but it's gone. And this case raises the question of, I make the parallel to a thing called SLAP, Strategic Litigation, and I can never remember what it's SLAPP. And it's typically where very wealthy individuals or big corporations take action against individual journalists to them to stop producing their information. So a journalist called Catherine Belton wrote a book about the rise of Putin, and she was sued by 4 Russian oligarchs. And what's it called? The Roscom, is it? The Russian oil company.
Yeah, that's the one. Yeah.
And it was settled, but it cost millions even to settle the case. And if she hadn't been, if it wasn't the publishers who picked up the tab, she would have been bankrupted for writing her book. Carol Cadwallader, the campaigning, the Facebook journalist who works for the Observer and the Guardian, she was taken to court by Aaron Banks.
Yes.
He was clever. He didn't take the Guardian to court. And it was something she said on a TED talk about him, the Russians. He didn't take TED to court. It stayed online, the TED talk. He took her to court.
And I'd highly recommend that TED talk, by the way. Carol, I mean, the bravery she's shown, considering she had received death threats momentary before she took on the stage to not do it, you know, her bravery to stand up on that stage and deliver that TED talk, you know, it's quite something to watch. So I recommend, and we'll post a link to that, you know, for that TED talk as well. SLAP, by the way, strategic lawsuit against public participation. Strategic lawsuit against public participation. There you go.
Thanks. And in fact, she actually won her case in the High Court. in June of this year, she was allowed to have a public interest defense. It was in the public interest for her to make these genuinely believed comments. But she would have been bankrupt, but she was saved by crowdfunding. So her defense was paid for by crowdfunding. And then there was the very sad case of the Maltese journalist, Maria. I have to look it up.
Caruana Galizia.
Thank you. You see, brain like a sieve here. But of course, this poor woman was assassinated for doing her job so well. But at the time she was assassinated, she was the subject of multiple SLAPP lawsuits, which continued against the foundation that bears her name for years afterwards. And there was even an attempt to use the right to be forgotten under the GDPR, and in fact, maybe even the right to erasure, by two businessmen who objected to comments she had made that the foundation was keeping alive. So my fear with this little local Italian website going under is that if you allow people to go willy-nilly against the little local news organization, maybe they feel more comfortable than going against big, bad Google, this big multinational company, then you have a sort of crowd-funded version of a SLAPP. Because, 240 requests and 40 cases, this was a two-person operation, him and his wife, and they just couldn't cope. And so for me, that is an extra dimension to the Italian case on top of the worry from the case from Belgium. Now, there is good news. The rule by the chamber of the Court of Human Rights in the Belgian case, the Urbain case, was appealed, and it was heard by the Grand Chamber of the Court of Human Rights last March. And if you can't find it, let me know. It's worth listening. You can watch the hearing online. And because we don't have access to all the documents and statements and intervention, it's the best way of actually seeing what was submitted to the court. Now, if the Court of Human Rights reconsiders the approach in Urbain, that will solve the problem for Biancardi as well. Because basically what I would like to see is we return to the Google Spain approach, where you go you complain to the search engine, and you say, please, would you dereference? And my criticism of the reasoning in both those cases is that they didn't apply the doctrine of necessity. When you infringe a fundamental right, the first thing that the court will look at is this necessary in a democratic society, and the wording of the Convention of Human Rights and the EU Charter. Why was it necessary? The dissenting judge, Judge Pavli, in the Urbain case, said it wasn't necessary to allow the newspaper to be ordered to dereference. It's actually more effective to have the dereferencing done by the search engine, because that's where people go. If you're interested in checking what happened in the past, you're not thinking, well, was it in Le Soir or Le Monde or the Times? You're not going to go checking all the newspaper sites. You go into a search engine. And Judge Pavli said that this should not have happened, this ruling at first. I call it first instance, the ruling in the chamber, because the effective way of solving this problem was to delist in the search engine results. If you searched by his name, this newspaper article would not come up as the first result. And then you leave it in the newspaper archives. So I see this as a strange example of when these human rights courts, which are really very, very good at analyzing the concepts of necessity and proportionality. And for proportionality, they did do a proportionality analysis. And they said, well, we're not saying that the newspaper should delete the information. We're saying that they should just delist it from results searching on that person's name. And so that's how they said proportionality.
Technology doesn't allow for it.
First,
then,
and second, it's less effective. If you want an effective protection of the privacy of that doctor or the 70-year-old restaurant owner, You ask Google to delist.
I will confess.
So, Chris, the one thing I don't understand, and maybe you also do not have an answer for that, but why was the journalistic exception not invoked? Because that would, even if you do a legitimate interesting balancing test for delisting of information, what the whole right to be forgotten actually is about, then surely the journalistic exception would weigh more than the individual right of somebody who can also have their goals achieved in another means.
I can only guess at it, but a couple of immediate reactions. Firstly, Article 85 is one of the famous opening clauses, and it's the biggest opening clause in the whole GDPR. And it says to member states, each of you find your own balance between privacy and data protection on the one hand, and freedom of expression on the other. So maybe that people thought, well, in Italy and in Belgium, this is the result of the balancing that they did under national law. But really, I think the problem is that the irony of it is that Article 85 and its predecessor in the Data Protection Directive, they were there largely because of the case law, the Court of Human Rights, which really was leading on the balance between privacy and freedom of expression. And you look at the case law on right to be forgotten, you'll see the same case law, the Court of Human Rights, being quoted. So it's a mystery to me why they didn't give. I can tell you why they said they didn't think this was a problem, because it was proportionate, because there was no obligation to delete. It was just to dereference. The other reason, by the way, the courts of human rights in those chambers behaved as it is, there is a margin of appreciation for the national courts. And they held in both cases that this fell within the margin of appreciation. But with the greatest respect, I don't entirely or at all agree with this.
So I'm not going to talk about.
Respectfully disagree. That's fine.
Yeah. I'm not going to talk about some bad press reporting, because actually, when the GDPR first arrived, most of the media, what the media told most people out there in the populace, is that everything relied on consent and you had the right to be forgotten. They were kind of the two headlines that you got from some very bad press reporting about the GDPR. And in my mind, what that led to is a lot of spurious right to be forgotten, right of erasure requests. And certainly with my customers as a consultant, I certainly see a lot of people asking for the right to be forgotten, the right of erasure, when they don't have that right. I mean, when you actually read the words of the GDPR, essentially within it talks about the right to be forgotten actually being a fairly limited right, right? It doesn't apply all the time. It only really applies if you're relying on consent. So what do? We remove the consent. You had to get rid of it anyway. You've got no legal basis. Or it applies when you've messed up against the principles. That's the way I describe it. You're holding data that's out of date, irrelevant, excessive, without legal basis. So
that's the problem with the GDPR, Ralph. The GDPR did not codify the Costeja case, because we basically have two rights to be forgotten now: the right to delisting on the one hand, and the right to deletion, which has been popularly called a right to be forgotten, at the wish of the European Commissioner.
So for me, actually, I'm going to go even further than that. And this is unusual as a privacy professional, so please don't lynch me when you see me at a conference. I often argue whether it was necessary to be in the legislation at all. Because if the only reason you have the right to erasure or the right for your data to be deleted is when the organization has messed up against the principles, or if you're relying on consent that you've withdrawn, well, that was kind of implicit anyway, right? You withdraw your consent, you don't have a legal basis, you've got to get rid of the data. You're holding it for longer than necessary, you've got to get rid of the data. So I even question its inclusion, whether it was implicit as a result of, non-compliance with the other areas anyway. And I wonder whether the inclusion of a right of erasure, right to be forgotten as a label has actually introduced into people's minds rights that they might not necessarily have. I come across this all the time in direct marketing, where an individual says, I don't want to be direct marketed, delete my data. And the organization involved, and there's a direct marketing organization, says, well, actually, can I not keep your data, but add you to the do not email list? Because if I delete your data, I could possibly reacquire you. I don't have any data that says I can't email you, so I might reacquire you and start emailing you again. So really, you want a suppression request rather than an erasure request. It's so hard to tell that to a member of the general populace who's just like, get rid of my data.
Ralph, there's actually case law that supports what you're just saying. I mean, starting with the Court of Human Rights, it was a Polish case. And then there was a Court of Justice case, which applied the same thing, which is that sometimes it's better to keep the information, but to add a note saying, do not send any more messages to this person. You just keep this information so that you know you don't start sending it in the future or whatever. So it's true. There are situations where it is better to keep the information. But I do think, if I can respectfully disagree with you as well, that there are situations, and I've just opened Article 17 of the GDPR, where the data are no longer necessary, which is the subject of these two cases, or they've been unlawfully processed is a good reason. Then there are situations where the full Monty for erasure is a good idea. But going back to Paul's comment, I'm looking at paragraph 17.3a, and it says that this right of erasure, and by implication the right to be forgotten as well, is that it shan't apply to the extent that processing is necessary for exercising the right of freedom, expression, and information. So it's there at the top of the list of cases where you shouldn't be interfering with the press. And I only repeat the point you made, Paul, that it is very odd the way that they didn't pay more attention to this point. And the question, I think, does arise: would the Court of Justice have handled this in the same way as the Court of Human Rights? And ironically, I would be tempted to think that the Court of Justice, which has been pretty faithfully following the case law of the Court of Human Rights, the Polish case about adding a note and leaving the information there, was cited in the CNIL case, where there was these people who had sensitive data being published, and one of them, it was about convictions, and the court said, you can keep it as long as you make sure that the balancing information is there at the same time. So the Court of Justice, which has been pretty good at following the case law of the Court of Human Rights, in this case, I reckon it might have been more faithful to the Court of Human Rights case law than the Court of Human Rights itself.
Is that GC et al. Versus the CNIL? GC about search engine operators.
Yep, that's the one.
That's the one. Yeah, I just looked it up really quickly. I wish I could claim that was available for immediate recall, but
it's not, and it might not be for everybody. So we'll put all the links to the cases that were referenced today in the show notes, as well as, of course, the link to Chris's blog. Chris, we'll have to wrap this up. We are already over the time that we promised our listeners that the podcast would take. Thank you very much for joining us to explain these fascinating cases. And indeed, a lot remains for us to keep wondering why this is happening, and hoping that the right to be forgotten will not be yet another sting to hit on local news reporting, because we need those local news reporters as well in the help to safeguard our democracies. Big words, but as the Washington Post calls it, democracy dies in darkness.
Oh,
on that note, thank you very much, everyone, for listening to another episode of Serious Privacy. If you like our episodes, rate and review us in your favorite podcast app or on the favorite platform. Join us for the conversation on LinkedIn. Find us at Serious Privacy, or join us on Twitter at Podcast Privacy. You'll find Ralph on Twitter as @IGROBrian. You'll find myself as Paul B, and Kay as Heart of Privacy. Until next week, hopefully again with Kay. She's back from her cruise. Goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure: non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No, That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.